Legal and ethical email and letter writing, safeguarding intellectual property. Hello everyone. Welcome to another lesson in our series on English language learning. Today, we're delving into the legal and ethical considerations when writing emails and letters at the workplace, focusing specifically on the issue of copyright and intellectual property. It's an important aspect of professional communication that is often overlooked, but it can have significant legal implications. So, let's dive right in. First and foremost, we need to understand what we mean by copyright and intellectual property. Copyright is a legal term describing rights given to creators for their literary and artistic works. These rights include the exclusive ability to reproduce, distribute, and display the protected work. On the other hand, intellectual property, IP, refers to creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images used in commerce. It's protected by law through patents, copyright, and trademarks, enabling people to earn recognition or financial benefit from their inventions or creations. So when we're talking about emails and letters in the workplace, we're talking about written materials that might be protected by these laws. Now that we have an understanding of these terms, let's move on to their practical application in workplace communication. It's crucial that we respect intellectual property rights when we write and send emails or letters. This means that we shouldn't use someone else's work without their permission. For example, if you are sending an email with an attached report that someone else wrote, it's important to ensure that you have the author's permission to share it. Furthermore, always give credit to the author or creator of the work. It's not just an ethical practice, it also helps to avoid copyright infringement. Spotting a copyright or IP infringement can sometimes be tricky. As a general rule, if you're using someone else's work without permission and it's not under the public domain or covered by fair use, it's probably an infringement. Keep in mind, even if you give credit to the original creator, it doesn't necessarily mean you're not infringing their copyright. For example, copying someone's blog post into an email and sending it out to a group of people, even if you credit the author, might still be considered a copyright infringement. When in doubt, it's best to ask for permission or seek legal advice. Ignoring copyright and IP laws can lead to serious consequences. In the workplace, this can range from disciplinary action to job loss, or even legal action by the original owner of the work. It could also negatively affect the reputation of your company. Understanding and respecting these laws is an essential part of being a responsible and ethical professional. That brings us to the end of this lesson on copyright and intellectual property in workplace emails and letters. Remember, always respect the intellectual property of others, and if in doubt, always ask. Ignorance of the law is not an excuse, and it's better to be safe than sorry. I hope this lesson has helped clarify the importance of this topic. Stay tuned for more lessons on professional communication. Happy learning!